Please be seated. Welcome, everyone. Thanks again to the Court of Criminal Appeals for hosting us and letting us use their facilities and online streaming. That we will be recording and broadcasting, so be on your best behavior. We have 3 cases set for today, 20 minutes per side. We will take a brief break between each argument. We'll begin with 1524-0014, Richard A. Hyde in his official capacity versus Harrison County. Appellates, who's present for appellates? Mr. Marks?
Jake Marks.
Splitting argument?
No, Your Honor.
So, I mean, all 20 minutes in opening or 15 and 5? That'll be fine. And for the appellee?
Susanna Naranjo-Pedro.
Ready? All right, let's proceed.
Good morning, Justices. May it please the Court. This is a substantial evidence case arising from an appeal of a $5,600 administrative penalty and an environmental enforcement order in which the county admitted to the underlying violations. The district court improperly reweighed the evidence, which was error. There are 2 primary reasons why the Commission's order should be affirmed. First, it is supported by substantial evidence. The county admitted to the violations in discovery, and it could produce no compliance records regarding these subject tests, even though there is a legal requirement that it do so. The entire record supports the violations, and there's no evidence to the contrary despite a full evidentiary hearing.
You speak up just a tad. Some of us are getting a little hard of hearing.
Of course, Your Honor. So second, there's no supplemental environmental project required in this case. The record shows the county rejected the opportunity to engage in such a project. It never proposed a project on its own, and there was no settlement prerequisite in this case that would afford for such a project.
Could you talk about how that works, the supplemental environmental project? Is it always the case that the party being investigated proposes one and then TCEQ looks at it, or does TCEQ propose one, or is it just different depending on the case?
It's a little different depending on the case, but for these compliant supplemental environmental projects where 100% of the penalty could go to correcting violations at a local government, that is a project that the county would create and propose. It would be its facilities that the project would apply to, and the commission does not create those projects for the county, and the statute does not require that it does.
So you say the penalty is then used to fund the project, or is in addition to the cost of the project?
The penalty would be used to fund the project, and it would not be in addition. In this case, though, the county did not propose a project, and in any regard, the county waived its supplemental environmental project because it did not raise that in its motion for rehearing in front of the commission. So at the outset, the context here is that these tanks and pipes storing the diesel and gasoline are underground. Leaks can go unnoticed for a great deal of time or even years if adequate testing is not done. So for that reason, these release detection tests are required. A TCQ investigator inspected 2 of the county's facilities, its road and bridges department, and its airport. These facilities having a cumulative capacity of 42,000 gallons, and found that the county did not conduct 2 tests at each facility for the year before June 18th, 2015. The county later admitted to this conduct in discovery, and the commission correctly found these violations occurred and assessed the minimal.
What was the admission specifically? Was it just the inability to show a receipt, or did they actually say we didn't do it?
Your Honor, the county actually said it did not complete each specific test. There was 4 specific requests for admission, 2 pertaining to each facility, 1 for each test, and the county went line by line and admitted that it did not conduct these tests in the year before June 18, 2015.
But did right after.
It did complete the tests after the investigation, and while that compliance is commendable, that does not alleviate it from the violation and the penalties.
Is that just statutory interpretation, regulatory interpretation, or is there any cases?
The rule specifically requires that these tests occur once per year, so that anytime an investigator goes out, there should always be a passing test on file. And the commission in its order found that these tests were not completed once per year, and that is consistent with Texas Government Code, Chapter 311, when it defines a year as 12 consecutive months. We look at one calendar date, and then we look at the next calendar date, the same calendar date, the following year. It's-
Yeah, I was a little confused by their arguments where they said as long as it's within a calendar, January to December timeframe each year, it's enough. Was there evidence in the record that they had actually done the testing prior to June of 2014, I guess it would be? In other words, somewhere between January and June of the, period before y'all went out and tested?
No, Your Honor, there's no record of any of these tests being conducted in 2014. And the commission's order is supported by substantial evidence. This, as this court is well aware, is a rational basis test. Courts should not reweigh the evidence. That is the job of the commission, and the record supports these violations, and there was no other reasonable decision the commission could make. In addition to those 4 requests for admissions that the county had responded to admitting to the conduct, there was also interrogatories submitted to the county where the county had a chance to explain whatever tests it had done before the investigation, and it could not name any. There were portions of TCQ investigation reports admitted into the record, also showing the violations, and there was testimony from an investigator and an enforcement coordinator at a full evidentiary hearing before an administrative law judge, who both testified the county was given ample chance to provide these records if the county could produce none. Yet, the county had a legal duty under the rules to maintain those records to demonstrate compliance. After that evidentiary hearing, the administrative law judge found for the violations, and the commission reviewed that proposal for decision, found for these violations. And as this court is aware, it presumes the conclusions, findings, and determinations of the commission, and it is a heavy burden for the county to overcome that presumption, and the county has not done that here.
If we agree with the county that at least once a year means once sometime during the year, we would defer to TCEQ's interpretation that no, that's not what it means, or should.
Your Honor,
That's a legal and statutory or regulatory interpretation question, right? Not factual interpretation.
that's correct, Your Honor. This court should defer to the agency when it's interpreting its own regulations, especially in the enforcement context, as long as those regulations are, and those interpretations of those regulations are consistent with the statute. And here we have the Code of Construction Act that lays out what a year means. The commission's interpretation of what a year is in accordance with that statute, and it should be afforded that deference as its interpretation is reasonable.
Survive the destruction of Chevron deference? I mean, can we still defer to you, or just at least once a year means a 12-month period with whenever TCEQ decides to come in and do an investigation?
Yes, Your Honor. Loper-Bright, it's not an issue in this case. The Chevron doctrine has not been applied in Texas state cases. The agency is still afforded discretion in this area.
So, have you looked through a brief Westlaw search and asked for statutes that say at least once a year or at least once every 4 or 5 years? And we got 248
Your Honor, the cases I found there are statute of limitations cases, and those cases apply Government Code, Chapter 311, the Code Construction Act, and courts consistently find a year means from one calendar date to the same calendar date the following year, or in these statute of limitations cases, it's oftentimes 2 years. But consistently, courts come down the same on this issue.
Well, I just searched my cases for the word limitations and I got zero. So why don't you take a look and let us know if anywhere in the 248 statutes, somebody's ever heard of this.
I'd be happy to, Your Honor.
That's the right answer, thanks. We'll have some law clerks that can back you up on that, but we would appreciate it all.
Of course, Your Honor. And just briefly, so I can give you perhaps some citations right now. In our brief, in our reply brief, we cited two cases, Ex parte Vieira, Salahat v. Kincaid, and Medina v. Lopez Roman on these issues, but I'd be happy to provide those. So going to the next issue of why this commission order should be affirmed, the county, again, waived its complaint concerning an supplemental environmental project. It was required to raise that complaint in its motion for rehearing before the agency. That is a requirement in the Texas Government Code 2001.145. It did not do that, so its complaint's waived. The first time the county raised this argument was the day of the hearing on the merits at the district court. And that's just far too late to brief this issue and have it considered for the first time. And so it was error to the extent the district court considered that argument. The county claims that the fundamental error doctrine salvages its complaint, but that doctrine applies to narrow contexts that don't apply to this case. For one, there's no subject matter jurisdiction issues involved in the supplemental environmental project issue. And then there's no direct public interest that's directly or adversely affected by the issue here. The county did not propose a project in the public interest, and the commission did not deny a project in the public interest. The county made that decision on its own when it never sought the opportunity, and it even rejected it. So along those same lines, those are really the same reasons why the county doesn't meet the statutory prerequisites here for such a project. There was no settlement, and the specific language of the statute says, in determining the amount of a penalty in an administrative enforcement matter, the commission may consider a respondent's willingness to engage in a project. There was no settlement here. The county was not willing, and in fact rejected that project. And if you go to the next statutory prerequisite here, there's really no project proposed that could bring the county into compliance with violations or remediate environmental harm. So that's another area where the statutory prerequisite is not made.
What would be a project that, I mean, if the complaint is it's leaking, not just that hasn't been run the test in a year. I mean, was there evidence that they're actually leaking, or was just evidence that they hadn't run the test?
The latter, Your Honor. There is only evidence that they did not run the tests.
So if you're right about the year, then what supplemental environmental project would fix that? What was the supplemental environmental project that
Well-
you proposed?
Well, there was none proposed by the county. The county and the commission does not propose that project for the county. And so the statute says that it would be a supplemental environmental project that would bring the county into compliance with environmental laws. So if the county could demonstrate there were other environmental laws that it was out of compliance with, it could have used that 100% of the penalty to apply to that type of project.
Unrelated.
It may need to be related in some regard to the violations, but there's likely equipment that could have been replaced or something like that, had the county chosen to engage in this opportunity. There was an enforcement coordinator at the administrative level that offered the county this chance, and the record is clear that the county rejected it. When the executive director filed the petition instigating the administrative enforcement matter in this case, and that's at 1 AR 6 at 2, there is a paragraph that re-extends the opportunity to the county to engage in a project, yet the county never applied. So for all of those reasons, the supplemental environmental project arguments by the county fail. The commission made a reasonable decision, and there was no basis to reverse it. So I respectfully request that this court reverse the district court and affirm the commission's order. And I reserve the remainder.
Any questions?
Excuse me.
Thank you, Mr. Thomas.
Thank you.
Mr. Ford.
May it please the court. Susanna Naranjo-Padron on behalf of Harrison County. The district court correctly reversed the SOA opinion in favor of Harrison County because the commission's order was not supported by substantial evidence. Further, the district court further reversed the SOA opinion because the county did not waive its complaints regarding supplemental environmental projects that it was not required to raise. Finally, the district court correctly reversed the SOA opinion because the commission inappropriately ordered an administrative penalty against Harrison County. I'll address each of these points in turn. Harrison County was only charged with a violation under Texas Water Code 26.3475, which is that there was a leakage of these underwater storage tanks. But in fact, the commission only provided evidence under Texas Water Code 26.3465 that there was failure to comply with showing the yearly testing requirements. The commission has a duty, has to prove under preponderance of the evidence that there was evidence of the violation, but it was unable to do so. It only provided evidence for the uncharged violation that the county hadn't produced prior testing records. It is the commission's responsibility to correctly charge individuals and entities. It is not the county's duty to accept whatever incorrect charges are set forth. The commission has argued that it has evidence of these violations, but the simple fact is that they did not provide evidence of the charge that they brought.
So is this like a special exception? They should have, when did your client first object that, hey, we haven't been charged with, all we've been charged with is leaking, not failure to take the test?
Since the beginning, Your Honor. The commission also argues that it's its duty to protect underground storage tanks against releases, but that duty does not absolve the commission of its error of first, assessing the wrong violations against the county, and second, not providing evidence under the preponderance of the evidence standard.
Let me ask you a question. So if a commission comes out and they inspect an underground storage tank, and there's no records provided showing there's been a test, isn't that at least circumstantial evidence that would favor the commission's charge?
It would be if they had brought the correct charge. But
So if they had charged for failure to test as opposed to leakage?
then we wouldn't be here today.
Okay. So what you're saying is there's no admission of a leak?
Correct. Commission's evidence regarding the testing of the facilities is a red herring because there was never any evidence of a leak at the site in the first place. During these investigations of the alleged violations, the county complied with the request from the investigator, but the investigator still testified the county had failed to comply. The commission has also argued that the county failed to comply with the requirement that testing be completed in a year. However, the statute does not define year, and a year could mean either 1 calendar year or 12 months.
Same question as for your opposing counsel. 248 statutes that appear to have something similar. Has anybody ever addressed this before? Surely we're not the first one.
Surely we're not, but I would also have to give you the same answer as my opposing counsel.
We'll take all the help we can get.
So just to make sure I understand y'all's statutory construction argument, you could literally test this upcoming December 31st and then test again on the next day, January 1st, and comply with 2 years of testing.
Yes, Your Honor, that is our argument.
Okay. And then the following year, you could wait.
It doesn't sound
until-
like a very good idea, does it?
It doesn't, but if they wanted a better idea, they could have defined year in the statute.
Was there a test in 2014?
Your Honor, we do not have evidence of testing in 2014. We would have to agree with opposing counsel on that. But as we previously argued, we weren't charged with failing to comply with the testing requirements. We were charged with leakage.
And so if there's no evidence of leakage, it would be your position that it really doesn't matter which way we interpret the statute, because either way, there wouldn't be evidence to support the charge.
Yes, Your Honor. The commission has improperly engrafted their own definition that the year is 12 months and into the statute and has tried to impose penalties on the county based on their definition. The county's argument that the year is a calendar year is just as valid as the commission's, and the county did comply with that requirement. If it were the case that the year means 12 months, the county would be denied due process because this definition has changed throughout the course of the proceedings. And although courts do give deference to agencies regarding technical decisions, this is not the case when penalties are to be incurred. Where there are penalties, statutes are going to be strictly enforced against penalties.
But didn't they charge you with violation of section 26.3475 of the Water Code?
Yes, that would be the leakage statute, Your Honor.
Well, I mean, we can call it a leakage statute, but it says basically that an underground storage tank system must comply with commission requirements for pressurized piping release detection system. And then there's an administrative rule that expounds on that and says the line leak detector shall be tested at least once per year for performance and operational reliability. So isn't it inaccurate to say it's a leakage test?
No, Your Honor, because the separate statute that they did charge us with is specifically regarding registration or certification. 26.3465, which they did charge us with, states that an owner or operator of an underground storage tank who fails or refuses to provide, on request of the commission, proof of registration or of a certificate of compliance for an underground storage tank is liable for civil penalty. So this statute is more specific than the stuff under 26.3475, and that is what we were charged with, not a violation of 3475.
You were charged with 3465, not 75?
Yes, Your Honor.
Okay.
Further, the commission has argued that we waived our right to a supplemental environmental project, but the county was not required to raise the supplemental protection issue. This was the commission's obligation based on its own rules, and failure of the commission to raise this constitutes a fundamental error.
Well, how would that work, though? I mean, you're the county, you know the needs of your county. How could they come in and say, like, well, here, do, this project? I mean, it seems like they may not know the situation on the ground. They may not have the best picture of what would be appropriate. So why should we interpret this potential remedy to be something that doesn't come from you?
Because under their own rules, they have to give us the supplemental governmental project. Under Texas Water Code .7067, the commission has to give local governments a supplemental environmental project if the local government has not previously committed a violation at the same site with the same underlying cause in the preceding 5 years. They didn't show any evidence of any violations in the preceding 5 years, and they never gave us a supplemental environmental project.
Do you know what any examples of a project would look like?
Unfortunately, I do not, Your Honor. There are very limited statutes, there are cases interpreting 7.067.
Does the statute say must give or must approve?
It says that they must approve.
So whose project are they approving?
They would approve ours, but they also didn't give us the chance to do so.
Let me ask you a different question, just a procedural one. I took it from your briefing arguing fundamental error that you agree, absent fundamental error, that you had to raise this in your motion for rehearing?
Yes, Your Honor.
Okay. So, and I'm not trying to be tricky, we agree that if you didn't raise the failure to give you a supplemental environmental project in your motion for a hearing, the only way you could argue it here is that it was fundamental error.
Yes, Your Honor.
Okay.
And the fundamental error is?
We were not given they didn't give us a supplemental environmental project, nor did they approve one, which again, under their own rules, has to be done because we didn't have a previous violation in the last 5 years in this site.
How do you know that you didn't have a violation in the last 5 years?
Because they never brought evidence of it, and it's their duty to do so.
But if they never come out, therefore we know there wasn't a problem with these storage tanks?
They would, if they wanted to prove it, it would be their burden under preponderance of the evidence to show that there was a violation in the last 5 years. It's not the county's duty to show that there wasn't a violation, it's the commission's.
And what's the amount at stake here?
I believe he said $5,800?
So would there be does the project have to be like along the same financial lines as the potential penalty, or what?
That is a wonderful question, and I don't have an answer to that.
Nobody knows.
Nobody knows.
How many underground storage tanks are there likely or estimated in Texas?
That's also a wonderful question.
I bet it's
Many.
100,000 or way more. I mean, I suppose a tank doesn't include salt caverns and stuff like that.
No.
Okay, so it's just dig a hole, put in a tank, and
Yes.
like every gas station does.
Yes.
Yikes.
Yes.
Okay.
So there are many. Since the commission didn't approve or give us the opportunity for a supplemental environmental project, this would constitute a fundamental error. And finally, the commission erred in ordering administrative penalties against Harrison County. Because the commission charged the county with the wrong violation, it also erred in ordering administrative penalties. The penalties the commission are allowed to issue is related to discrete violations that are not at issue in this proceeding. There might be violations under other provisions of Chapter 26, but as previously argued, the commission is not responsible for bearing the commission's mistake in charging it with the wrong violations. When the legislature intends for underground storage tanks owners and operators to be liable for penalties under Chapter 7 of the Water Code, it enacts statutes explicitly providing as such. However, there are no provisions under Chapter 26 authorizing the assessment of administrative penalties against any underground storage operator, much less a county, concerning an alleged violation of Section 26.3475. Rather, that same section limits enforcement of the issuance of a notice of violation in order that a non-complying underground storage tank system may be placed out of service. For these reasons and the reasons presented in our briefing, we ask that this court affirm the decision of the district court. Thank you.
Any other questions? Thank you.
Thank you.
Mr. Marks?
Could I start you off with a question?
Of course, Your Honor.
How do you respond to the point that you've charged the wrong provision here?
Your Honor, the state does not agree with that claim. The state charged, as Justice Field pointed out, Texas Water Code 26.3475A and 30 Texas Administrative Code 334.50B2. Those were pled in the executive director's petition at 1 AR6, and those are the same citations that appear in the commission's final order. That's at 2 AR32 in conclusion of Law 13.
But those are not the specific 3465 that says you got to run a test once a year.
Those two statutes specifically are that the county has to conduct release detection in accordance with the commission's regulations. So the commission did not allege violations that a certificate of compliance was not provided nor is that the correct violation here. These are release detection test violations, and nor did the commission allege that there was an actual leak in this case. These are specific testing violations that the commission has alleged since the beginning. And to briefly respond to one point by the county, it is not the administrative law judge's proposal that's at question. That is not the issue before the courts. It's the commission's final order. So to the extent the county is raising arguments, new arguments against the commission's final order, and those did not appear in its motion for rehearing, those are waived. And I'd like to take the remaining of my time to address some of the supplemental environmental project points that were raised. I want to reiterate that there's no statutory requirement that the commission must propose a project for the county. The language is shall approve, and that necessarily means that a project must have been proposed to it so it could consider that project for approval. Because, in addition, because the other statutory prerequisites are not met under Texas Water Code 7.067, the settlement prerequisite, the willingness to engage, the proposal that the county actually had a project that would bring it into compliance with environmental laws, we don't get to the final two prongs, the no repeat offender or the no prior agreement prong. Those just don't come up in this case. And I guess since I have just a little bit more time, there's an argument about the only appropriate remedy is to shut down these facilities under 26.3475E. That is a permissive authority that the commission has, but the commission did not use that in this case. The commission instead relied on its authority under Texas Water Code 7.051 in issuing administrative penalties, and it may do that for any violations of statutes or rules under its jurisdiction. If there are no further questions, I will conclude. Thank you very much.
Very succinct. Thank you both. We'll take a brief recess.
All rise. jurisdictional discovery and directs the trial court to consider the jurisdictional discovery and evidentiary attachments and arguments submitted in connection with that.
So what does, I'm not a major kind of a Google person rather than a Yelp person, so I understand, how does Yelp work? They don't go out and find all this stuff, or do people input all, I know people input their opinions, as all my daughters do. So where do the listings come from? Who divides them out? That's Yelp's activity?
That is Yelp's activity. I do believe the businesses themselves can update the information. However, if a business is listed on Yelp and wishes to delete or alter certain parts of the listing, sometimes they are not permitted to do so, so long as it's still in business.
And how does Yelp make their money?
Yelp makes their money in multiple ways, but it's all connected to the location of various businesses listed on its platform. So Yelp, to do a search on Yelp at all, you must enter what you're looking for, and you must enter the location. You cannot do a search without entering the zip code or the town. So it makes money in two ways. First, in the search results, it will sell advertisements to recommend certain businesses higher ranked than others. And then second, anytime a user on Yelp enters search data, Yelp is collecting their data of the search and their location, if they have location turned on, and using that both internally for advertising purposes and selling that to others. Thank you. Specific to this case, the conduct that Yelp engaged in of the manually tagging Texas businesses and then adding the disclaimer, ignoring their complaints, well, several Supreme Court of Texas cases have already held that that is more than enough for purposeful availment of this forum. For example, in the Supreme Court of Texas case Siskind v. Villa Foundation, the court held that advertising in Texas telephone directories alone was sufficient to purposely avail itself of the Texas forum. Well, here, Yelp is the telephone directory. It essentially is a modern-day phone book. It's hosting these geographic-specific, location-specific business listings.
But what about the argument that, you know, they did this nationwide, you know, they weren't doing anything specific to single out Texas?
So the Supreme Court of Texas already rejected that argument in the case State v. Volkswagen at Tingelschaft. In that case, the Volkswagen is in Germany and had directed its third-party dealers in the United States to send out an illegal software blast to all cars, including cars in Texas. The court held that even though Volkswagen never set foot in Texas, and even though it was a nationwide software blast, that was sufficient for purposeful availment, and specifically held that the defendant need not single Texas out in some unique way. Because it is causing a consequence in Texas, because it is in this case, because Yelp has harmed Texas businesses and misled Texas consumers in a way that was foreseeable, that is sufficient for purposeful availment under Volkswagen.
And under the DTPA for AG enforcement actions, do you have to prove anybody was misled or anything like that, or is just this deceptive practice occurred, period, end of story?
So that's more of a merits issue. We haven't really gotten into that yet at this stage of the case. So we don't really have any discovery yet as to that. The burden for the Attorney General pleading a DTPA claim is lower or different than for a consumer. A consumer has to prove that they were actually misled. The standard for the Attorney General is just that it is could be misleading. So that is, but again, that's a merits issue we haven't gotten to yet. But we do know that at least one Texas crisis pregnancy center did reach out to Yelp and complain, this is misleading, this is harming our business. We have licensed medical professionals on site and we will send you that documentation, and Yelp did not respond to those
What
claims.
was
I'm sorry.
What was the time frame on that, when the complaint was alleged versus when the language was changed?
So the misleading disclaimer was put out right after the Dobbs opinion was published, so that was in the summer. And then the disclaimer was up for about 6 months, and I'm not sure of the exact date, but sometime in that 6-month period is when the crisis pregnancy centers were reaching out, making a complaint, not being heard. Only several months later, when the Texas Attorney General's office and several other states sent a formal letter to Yelp, did they agree to take down the misleading disclaimer.
And that was within 24 hours?
It was within 24 hours of the Attorney General's complaint, but they had already received several complaints from from businesses saying, this is misleading, this is hurting our
And
business.
what's happened, just by way of background, have the other attorney generals filed suit? Have other courts in the Yelp, this specific Yelp Crisis Pregnancy Center case, addressed personal jurisdiction?
So Texas is taking the lead here. I'm not aware of any other states that have brought suit, but that's in part because Texas has by far the most crisis pregnancy centers of any state in the nation. We have over 200. The next highest, I believe, is California. Obviously much bigger, but they only have 150. So this is an issue that uniquely affects Texas businesses and Texas consumers, especially in rural parts of the state where maybe a crisis pregnancy center is the only nearby location for pregnancy care. So similarly, the Fifth Circuit held in Wine Air Alaska v. Brandt that when it comes to purposeful availment for specific jurisdiction, a misleading statement sent into Texas can itself be sufficient for purposeful availment, which would here be just the misleading disclaimer being put on these Texas business listings would be sufficient itself.
But, so Michiana Easy Living said, you know, a misleading statement in a phone call, unsolicited phone call, but an unsolicited phone call, misrepresented state, if you know you're talking to a Texas resident, that wasn't enough.
I think the difference here is that it wasn't, obviously it's not a phone call, so it's not unsolicited in the same way, but here Texas had its employees manually go through these listings and pick out each Texas business that's listed as a crisis pregnancy center was put there by a Yelp employee. This was not done by algorithm. They did not ask to be in this category, and they couldn't be removed if they asked unless Yelp determined that they were no longer a crisis pregnancy center on their own. So Yelp was taking the affirmative step to create this category. They affirmatively put every single Texas business in there in that category, and then they affirmatively took the step to tag all of those businesses with this misleading disclaimer. Similarly, because a purposeful availment is itself this tagging of the businesses and the misleading statement itself, this is clearly related to those contacts. Is alleged in the state's original petition, Yelp's misleading disclaimer diverted consumers from seeking pregnancy resource center services in favor of other facilities that lacked the misleading disclosure. So there is a clear connection between the availment, the disclaimer, and the DTPA violation in this case. With my remaining time, I'd like to discuss consent jurisdiction under Mallory. So in Mallory in 2023, the Supreme Court of the United States reaffirmed its earlier precedent that you can have consent to general jurisdiction or any kind of jurisdiction in a state by a corporation by virtue of state statute. And specifically in Pennsylvania Fire, the court held that this can be true even if it takes the defendant by surprise. And in Mallory, the court reiterated this can be true if it's express or implied. So even implied consent, anything that could be viewed under, say, the world of contract law that would evince implied consent, if there's something similar in state statute, then there can be implied consent to jurisdiction.
Just open the floodgates for jurisdiction in every state.
This doesn't open the floodgates for many reasons. Not every state has the same statutes that we do. And furthermore, in Mallory, the court considered that argument and said, well, at the end of the day, it doesn't violate due process requirements. So that case involved Pennsylvania. They said whether this opens the floodgates or not, it doesn't violate the requirements of the Constitution because these companies do not have to register to do business in a state. They choose to do so, and there are consequences to that.
So, am I reading Mallory right? It's really a 4-1-4 decision. 4 say the Pennsylvania statute, registration statute was enough. 4 say it wasn't. And Justice Alito says, well, I think it's enough, but I think our precedent, Pennsylvania Fire, may be unconstitutional under the Commerce Clause. Now, what are we supposed to do?
So thankfully, there are some sections of the opinion that are a plurality and some that are a majority, some that Justice Alito did sign on to. And all of the provisions I've been citing and that are cited in the brief come from the 5-4 section of the opinion. The court may.
But only because he said, I'm with you, but I'm remanding, and you can start that all over again, and it may all fall apart because it's all unconstitutional.
Well, it may, but for now, the court has said in Mallory that this is what we have, and Texas statute, Texas code is fairly consistent with what was present in Mallory and in Pennsylvania Fire. Now, in Mallory, the court specifically said that under our precedents, a variety of actions of the defendant that may seem like technicalities nonetheless can amount to a legal submission to the court. So it definitely seems unfamiliar in this world of international shoe precedent, and I think that's why some courts have been hesitant to adopt it, and why, as the court observed in Mallory, so many courts had treated Pennsylvania Fire as implicitly overruled. But the court said, no, it is not implicitly overruled. This is international shoe is an additional road to jurisdiction, but this kind of jurisdiction is still available.
But if California has the same registration statute, and a California federal or state judge says, we're gonna try all Yelp cases in all states about pregnancy centers in Texas, Louisiana, and everywhere else, in Northern District, California, and effectively, I think Yelp filed what looks like an anti-suit injunction, didn't grant it, but I suppose others might. We're gonna end up in some kind of conflict, if not war, between which state yanks all the good DTPA cases.
Well, 2 points. First, the DTPA says that claims can only be brought in Texas court, which I think is an important point for this case, because if there's no jurisdiction over Yelp here, there's no jurisdiction anywhere for its violations of Texas consumer protection law. Second, we know what will happen because we saw what happened after Mallory in Pennsylvania. A bunch of out-of-state corporations that were registered to do business in Pennsylvania withdrew their registration. It hasn't so far had any kind of seismic effect or impact that we can see. Obviously, it's still early days, but they're dealing with that in Pennsylvania, and people have, companies have their general counsel departments. They can weigh that risk-reward analysis. But the main point of Mallory and Pennsylvania Fire is that while it may seem unfamiliar, it does not violate constitutional due process requirements.
Are you aware of any other cases where this argument is being made as to Texas law currently?
So there are a few other cases where this argument has been made to with regard to Texas law. None have been successful. However, none of them raised the statutes at issue in this case. So for example,
But these particular statutes that you're...
That's correct. Of course, there are also first Court of Appeals cases from a few decades ago that did hold under Pennsylvania Fire. There is jurisdiction here. So there is a split. The first court has said there is jurisdiction. Other courts have said there are not.
But nothing post-Mallory.
There have been some post-Mallory, but the main one post-Mallory just came out of the Fifth Court of Appeals in Dallas, but specifically, and it's important to note, the only Texas statute the plaintiff raised in favor of jurisdiction was a statute that's not even at issue in this case. It was simply the long-arm statute. They didn't cite the registration statute. They didn't cite all of these other sections. They didn't even cite the Business and Commerce Code. It was a completely different code. So it doesn't have any bearing on this case.
Thank you.
Thank you.
Ms. Prather.
Good morning. May it please the court. I'd like to start where the court just left off with regard to Mallory and some of the statements that were made by my friend on the other side. First of all, the DTPA can be brought anywhere, and in fact, the venue provisions under the DTPA expressly provide that it can be commenced, that a DTPA action can be commenced where the principal place of business is, where the person against whom the claim is brought resides, and where they have done business. So that is very clear, and in our brief, we list a number of cases in which DTPA claims have been brought in other jurisdictions. Second, with regard to Mallory, Mallory was a decision based upon an extremely narrow and unique law in Pennsylvania where the U.S. Supreme Court simply said the Pennsylvania law is constitutional.
But mostly what it said was we're bound by Pennsylvania fire, and the Pennsylvania fire statute was not very unique.
I'm sorry?
The Pennsylvania fire statute was not very unique. It required you want to do business in Pennsylvania, you've got to get a registered office, you got to have somebody that'll accept service of citation, which is exactly what ours has said for, what, 100 years?
Well, the Pennsylvania law has an express provision that you are consenting to the exercise of general jurisdiction,
And Mallory it did, but it didn't in Pennsylvania fire, is my point.
which was the Missouri law. And the Missouri law,
Sorry.
yeah, the Missouri law we talk about in our brief, and we talk about the fact that 10 years later in the Dolan case, the court said, you know what, we actually misinterpreted the Missouri law. It does not provide for consent jurisdiction. And then 100 years later, it reconfirmed
Said,
once
yes, it
again
does.
that they got it wrong, that Missouri law does not provide consent jurisdiction. Now, Your Honor.
Maybe I'm reading Justice Gorsuch's opinion, but he seemed to say, as did Alito, we've decided this already in Pennsylvania fire.
We've decided that if a state court has deemed a law to provide, like if the state court's interpretation of the law is that it provides for general jurisdiction, that is constitutional. All Mallory said was, if that statutory construction has been made by a state court and we are evaluating the constitutionality, does that comply with due process? That complies with due process. But here, the Texas statute has no analog, and the state has admitted it on page 16 of their brief. There is no analog to the consent to the exercise of general jurisdiction in Pennsylvania. And in fact, the chart that's attached to our brief, which is Exhibit B, goes through all the different state laws, and it talks about all the different provisions for foreign registrations. And you see that Pennsylvania is a complete outlier. And the state concedes that. They are a complete outlier because they have an express provision with regard to consenting to general jurisdiction. I think Justice Field's point is if this court were to go against a litany of other courts, and there have been a litany both pre and post Mallory that have interpreted the Texas foreign registration statute as not providing consent jurisdiction. If this court were to go the other way, it would open the floodgates of litigation. It would be a seismic shift in jurisdictional analysis in Texas.
I hear that argument, but when I read the opinion, it's making an analogy to tagging jurisdiction. And tagging jurisdiction is where somebody drives through a corner of the panhandle. You serve them there, they're present for their divorce case in Alaska, everything else. And Justice Gorsuch draws a exact parallel to, well, so where's a corporation present? We used to all think it's where they're headquartered and where their principal base of business is. But why isn't it where they register to do business? I mean, when you register to do business, you get the benefits of the forum state. Why shouldn't you also get the burdens? In other words, being subject to jurisdiction there.
And 22 states have looked at this issue post-Mallory, 22, and they have all said that doesn't constitute consent jurisdiction.
It doesn't. This is, we're talking about due process. It doesn't matter that we all thought it had to arise. Supreme Court says in Montana versus Ford Company, forget about it. It's related to, it's not arising from. And they write the rules. And so I'm trying to divine what they are gonna do. Maybe we shouldn't, maybe we should wait for them to do it. But the fact of the matter is, I'm not persuaded by if 49 other states say it. If Justice Gorsuch picks up one more vote, that's the law, right?
Justice Gorsuch was looking at the constitutionality of a law that had already been interpreted by the Supreme Court in Pennsylvania. That's the difference. So here, we've got a Fifth Circuit case, pre-Mallory, which was the,
Wait a second. I thought the Pennsylvania Supreme Court said we don't have jurisdiction.
The Pennsylvania Supreme Court interpreted the statute as providing for consent jurisdiction. The U.S. Supreme Court said that is a constitutional law. That's all the Supreme Court
Are
was
you
saying.
whispering for some reason?
No, I'm sorry, Your Honor. I'll try to speak up more.
Thank you.
But the jurisdiction, let's talk about the jurisdiction in Texas, okay? So pre-Mallory, the Winch-Seymour versus Learjet case is out of the Fifth Circuit. It looked at the Texas law, and it said, the Texas law does not provide consent jurisdiction. There are a number of other courts, the Corpus Christi Court, the Dallas Court, the 14th Court, all of which are cited in our brief, pre-Mallory, that agreed with that. They have cited one outlier case, which is the Acacia case out of the First Court of Appeals that has been disapproved repeatedly by all of the other courts. Then post-Mallory, we've had to do a number of supplemental briefing in this case because Mallory was decided in June of 2023. Post-Mallory, there have been a number of cases that have reiterated the Texas statute does not say the same thing as the Pennsylvania statute. And those cases we supplied to the court are the Asset Works case, the Morris versus Kansas City Railroad case, and the Repairify case. Our statute simply doesn't say what they want it to say. And
Are there any cases that are still in the works? Sorry, I might have not been clear, but are there any that are pending currently where that issue is going to come up that you're aware of, that beyond the ones that are cited in the briefing, that the issue is still outstanding somewhere else?
There's a case out of the 13th Court of Appeals involving Google, but I don't believe that they pursued the consent jurisdiction theory in that case.
Help us on the specific jurisdiction.
Sure, I'd be happy to, and I'd like to do two things here. I'd like to both clarify the facts and clarify the law. So, first of all, the facts. I think that Justice Ferris was spot on. The pleadings in this case simply don't suffice. They did not, under Kelly, articulate. First of all, they didn't articulate this consent jurisdiction theory at all, and they also didn't tie the facts of the case, the actions of Yelp, to the operative facts of the issue concerning the consumer notice. And they can't, because all of those activities, the things that they talk about, the sifting through the various business categories, all that took place in California, and those are undisputed facts in this case. So they haven't met their pleading burden, and their pleadings that have to be considered are their petition, and paragraph 4 of their petition is this sole paragraph that deals with jurisdiction. The attachments and the affidavits to the response to the special appearance, that only talks about Texas users, which are not at issue here in this case, because we're talking about the connection between Yelp and the Texas Forum, and that's it. And so,
Can we not look at the facts that are pleaded with respect to the causes of action, though? I mean, are we restricted to that jurisdiction paragraph, or can we?
you can look at that, but even that, so that's actually incredibly telling, because the facts that are pled talk about this consumer notice, and they talk about the fact that the consumer notice was posted nationwide. Paragraph 28 of their petition, I actually think, is decisive in this entire case. It says, Yelp, quote, specifically targeted crisis pregnancy centers nationwide.
Okay.
That was
So,
who they targeted.
distinguish Keaton versus Hustler for me. I mean, there's the defamed plaintiff lived in California, everything was done in Florida, so let's sue in New Hampshire because they've got a longer, New Hampshire, Vermont, because they've got a longer defamation statute of limitations. Supreme Court, I seem to recall it was Justice Rehnquist seemed to think, well, that's fine because they sold 10,000 copies. Right. And I mean, that looks solely for minimum contacts, assuming that's involved, at how much business they did in the state, which kind of feels like the Montana case as well. And both of those cases, nothing involving the car wreck, involving the defamatory article and publishing it, nothing occurred in New Hampshire.
And nothing occurred in Texas here, right? So the difference between that case and this case is you're talking about them making money. And this also goes to the question about how does Yelp make money?
Right.
Yelp made no money on the consumer notice. The consumer notice is a consumer advisory. It is a passive piece of information, Revel versus Liddell it should be a full stop on jurisdiction right there. There's no interactivity.
But this day
No
and
money
age
was made.
Is political capital and goodwill a benefit? Let's say the hypothetical is totally different. Let's say, I won't even use Yelp's name because it's my hypothetical, they wouldn't appreciate it. But let's assume there's a internet company that's owned by a white supremacist. And that white supremacist looks for every minority-owned company in the United States and decides to put out a hit on their site online to drive business away from them. Is it different?
Where did those acts take place? For Yelp, the acts all took place in California. That is undisputed.
Because it's that hypothetical, we'll assume southern state, some southern state, this website's owned, all their employees are there, they send it out nationwide. Are we saying that white supremacists didn't get a benefit by driving business away from the minority community?
What we're saying is there are multi-factors, right, that deal with specific jurisdiction. The first is relatedness, and there is no relatedness if the actions that are dealing with the operative facts didn't take place in Texas. Here, none of those actions took place in Texas. That is an undisputed fact.
Well, could I ask just a follow-up that I think tags along here? I mean, it seems like if you wanted to drive business away from somebody, it would be much more effective to go put something negative on Yelp, which everybody looks at, than to like go spray paint their front door, because it's going to have a stronger effect in Texas because people who are in the neighborhood are going to, if it's a restaurant per se, they're not going to go show up at the door and ask, customers, hey, how was your meal? They're going to go to Yelp. And so if you were wanting to harm a business in Texas, wouldn't that be about the most effective way you could do it if that's what you were trying to do?
First of all, I don't think, I believe I understand the court's question. I don't think that deals with the jurisdictional issue here. But if Yelp were truly, like, if we're gonna get down to that level, if Yelp were truly trying to harm crisis
Yeah, and I'm not
pregnancy
saying that they
centers-
are at all. I'm just saying, like,
Right.
in our internet-connected age, isn't it more effective to go put something online that's tied to somebody's address than to actually go to the physical place?
I mean, I think what would be more effective is taking out the category altogether, removing all of those businesses from their webpage. If they truly didn't want anybody to go to a crisis pregnancy center,
That would be the logical.
that would be what they would have done, and that's not what they did
What happened
here.
here.
And so what we're dealing with here is we're dealing with specific jurisdiction where they have no facts that are related to the operative facts, no actions taken in Texas that are related to the operative facts. That is undisputed in this case. And instead of having purposeful availment, we have purposeful avoidance, because we have a situation where the consumer notices, they made no money on those consumer notices, and they have a forum selection clause that has to be considered as well under Michiana. So the cases that the state relies upon, the Siskin case, the VW case, the Wine Air case, none of those are applicable here. The Siskin case was a contract case where they actually wrote out of the contract the forum selection clause. And it's been discredited by at least 14 other courts of appeals. If you look at note 15 in our appellate brief, we talk about that. The VW case is a case where the manufacturer continued to control the process in Texas of putting the software on the cars in Texas. Those actions took place in Texas. They profited from that. They got over $500,000 per month from that faulty software being put into the cars, and they serviced more than 23,000 cars in Texas. All of those activities took place in Texas. Nothing Yelp did here happened in Texas. And the Wine Air case talks about in-person meetings in Texas. Again, there is no in-person meetings that took place in Texas. Here,
So that has changed. That's what the Montana case changes. The Facebook versus Doe, where the 14th court, I mean, this was a sex trafficking case. Somebody befriended on Facebook. Facebook didn't make any money from that friendship thing. Facebook did all of the decisions about setting up who can befriend who and age restriction, all of it in California, nothing in Texas. They have a lot of employees here, but none of them we're doing security or any of that stuff. All that stuff is in California. And 14th Court says, yeah, but they're making a bunch of money here. It's related to their activities that are available here. And happen to know since I was involved in that case, we appealed to the Texas Supreme Court and they denied it. So why is it, I understand the emphasis, that used to be the deal. We didn't do anything here. But isn't that passé now?
I don't think it is, Your Honor. I mean, if you look at the very recent case from the Fifth Circuit that we put in our notice of supplemental briefing, the Fernandez versus Jagger case, that's a case where the songs were created, the content was distributed all outside of Louisiana, and the Fifth Circuit said, doesn't count. The Huffington Post case, similarly, and Huffington Post is very, very similar to this case, and some of the same exact arguments have been made in that case and been rejected. In the Huffington Post case, the court said, not sufficient because none of the content was created in Texas. So I think we've still got courts that have repeatedly held that operating a nationwide website does not confer jurisdiction, and that is what is happening here. And it's even more significant here because you've got a consumer notice that is not an interactive consumer notice and on which they made no money. So if you look from relatedness, both sides, there's no Texas-directed activity in the creation of the content, and then there's no Texas-directed activity in the distribution, which the court can see in paragraph 28 of the state's petition. They specifically say, they identify for the court who's being specifically targeted, and they don't say Texas consumers. They say crisis pregnancy centers nationwide, and they say that throughout their petition 3 different times. There's no reference to Texas consumers in there. And then also, when it comes to the fair notice, or to the fairness, fair play, and substantial justice, here you're looking at, according to Bristol-Myers, primary concern is the burden on the defendant. We have no offices here. Yelp has no property, no facilities, no data management. All of that under Berry versus Breach should be enough to say no jurisdiction, even if they did make money on peripheral issues. The other issue, and one that's significant, again, under Huffington Post and under Nicastro, is you're upsetting the balance of the sovereignties here. Here you've got another jurisdiction to file this lawsuit. You've got a principal place of business in California. You've got a place of incorporation in Delaware. If every state attorney general filed lawsuits in their own states over a national website's consumer notice, you would destroy those state sovereignty and the federal balance that exists. So in this case, the exercise of personal jurisdiction over Yelp on facts where all of the contacts all arise out of California, and they were at most posted electronically nationwide, it simply does not comport with constitutional protections of due process. So we would request that this court affirm the trial court's ruling.
Any questions? Thank you, Ms. Fraser. Yes, ma'am.
Thank you, Your Honors. I'd like to clarify a few points. First, under the DTPA, the Attorney General can only bring a DTPA claim in Texas state court. So regardless of what consumers may be able to do.
Which section is that?
I do not have it offhand, but I can submit
I don't
it.
either, that's why I was asking.
Thank you. Second, regarding the facts, Yelp says that the state made no allegations regarding whether they manually set up this category. The state didn't need to because it's in Yelp's allegations and evidence that it's submitted below. Specifically, page 5 of Yelp's appellate brief references SCR 26 paragraph 15, which was part of its submissions during jurisdictional discovery, which lists out that its employees sifted through thousands, I believe it's actually tens of thousands of pregnancy care provider listings to go through and tag over 200 Texas businesses.
Could I ask just a quick follow-up question?
Yes.
Is it true that every, basically every consumer protection notice that Yelp would put out nationwide would result in jurisdiction in Texas. If we buy your argument, does every nationwide tag create jurisdiction here?
No, for several reasons. First, if that consumer notice is misleading or not. There is currently a Yelp consumer notice on crisis pregnancy centers in Texas that is not the subject of this suit because it's not misleading, it's accurate. Second, that misleading notice would have to be.
That's not something we would decide on.
On jurisdiction?
No, that's a merits issue, but just to say, we're not going after them for things that we don't believe are misleading. Obviously, a nationwide notice that was not attached to Texas businesses would not be subject to jurisdiction here. So it would both have to be something that affected Texas businesses and or Texas consumers, and it would have to violate some law. So one presumes the vast majority of their consumer notices would not violate the DTPA. This one does. This court has jurisdiction over that. Again, going back to the discussion here, my friend talked a lot about how all of this process took place in California. The Volkswagen case says that does not matter. In Volkswagen, all of the actions were taking place in Germany. The software was being developed there. They were sending it to be directed to be put out nationwide. It didn't matter that it was coming from Germany. It didn't matter that it happened the exact same in every single state. The Supreme Court of Texas said, a defendant's contacts with other states do not negate purposeful availment of this jurisdiction, regardless of whether out-of-state contacts are more, less, or exactly the same. And it did so citing the Supreme Court Keaton case that was referenced earlier. Just one little thing, the original petition does mention harm to consumers at CR 6, which is part of our petition. And finally, Yelp talked about how they really worked hard to avoid our jurisdiction, but the Supreme Court of Texas has held that when it comes to personal jurisdiction, intent does not matter. In the case Moncrief, the court held what the parties thought, said, or intended is irrelevant, regardless of the defendant's intent. If they do acts that avail themselves of this jurisdiction, they are subject to jurisdiction here. Unless there are any further questions, I ask that the court reverse and remand.
Thank you, Ms. Smith. We'll take a brief break before the last case.
All rise.
please. So we'll call 1524 00043 TIEC versus PUC et al. Who's present for appellates?
Mike McMillan for TIC.
You be doing 15 and 5 or sharing argument or?
15-5, just TIC.
Good. And let's see, for the PUC.
For the PUC, John Hull, I'll present 15 minutes, and amicus curiae will take 5 minutes.
So we'll count on you to keep an eye on that. I'm not gonna watch, since I have no clock to watch, I will, when your time's gone, your time's gone.
Okay.
I mean, will you keep, do you all have minutes up there? Because we don't.
Judge,
Yeah, there's a time.
Okay. So stop when you get to 15 minutes if you want Mr. Elliott to have a chance. You may proceed.
May it please the court. Texas Industrial Energy Consumers, or TIEC, is an association of large industrial companies, and many of our members are corporate members of ERCOT. Our members have been involved in ERCOT's governance since ERCOT was created in 1970. And in the year 2000, the Public Utility Commission certified ERCOT as an independent organization under the Public Utility Regulatory Act. And their purpose as an independent organization is to create and enforce rules governing the state's power grid. Now, when ERCOT became an independent organization, the commission gained broad authority over ERCOT. And significantly, that authority includes approving changes to ERCOT's bylaws. But nothing about being an independent organization changed the fact that ERCOT is a nonprofit corporation. And as a result, ERCOT continued to be governed in accordance with its governing documents, its certificate of formation, and its corporate bylaws. And for over 2 decades after ERCOT became the independent organization under PURA, there had never been any dispute about how to amend ERCOT's corporate bylaws. So internally at ERCOT, that process involved 2 votes. First, you would have a vote from the board of directors to approve a bylaws proposal. Then, you would have a separate vote by the individual corporate members after the board had their chance to approve them. And the next step was for the amendments to be approved by the PUC. And that process was always conducted using contested case procedures that are described in the PUC's rules. But in late 2022, the ERCOT board and the commission abruptly abandoned the bylaws amendment process that they'd applied for decades.
Well,
And
isn't it true that they made, used a different procedure once before?
so they did use a different procedure before. Shortly after SB 2 was adopted in 2021, the board used a separate procedure within the bylaws that gave the board authority to construe the bylaws to conform with legal requirements. I believe I quoted that correctly. And that's under section 14.2 of the bylaws. And they did that in order to faithfully pull in language from SB 2 about changes to the makeup of ERCOT's board. Now, it's TIEC's position that we could have challenged that, but given the fact that it just faithfully brought in the exact statutory language, no one was gonna hire me to do that. So,
So
they,
if PUC wants the bylaws to change, is there anything ERCOT or your clients could do about it?
so yes, and this is something I was planning on getting to later, but under 39-151, I believe it's G1 that ERCOT discussed in their brief, the commission has the authority to approve ERCOT's bylaws, and it also says that the bylaws, must reflect the input of the commission. Now, traditionally, what that has meant is that when ERCOT sends approved bylaws amendments up to the commission can comment on them and provide changes if it so desires. We've never had a situation before, to my knowledge and based on my research, where the commission just directed ERCOT to change its bylaws in a specific way. It was always more of like a back and forth. Proposed changes came up from ERCOT, and then the commission commented on them.
Yeah, I mean, it's an interesting situation because it seems to me we've had a bit of a sea change with the Supreme Court ruling that ERCOT is basically a governmental entity, at least for immunity purposes. I mean, that itself is a sea change, it seems to me, in terms of how ERCOT is viewed, how it's run. And why isn't this change, which seems to me is PUC directed, why isn't this just like the one before it that y'all didn't challenge?
So the one before that we didn't challenge was explicitly based on the statutory language. The statute said the board shall be made up of, and then they changed the bylaws to say the board shall be made up of. So that's the distinction really, is that the legislature told ERCOT to do something. Even if we did challenge it, where are we gonna get?
It's legal, you have to comply with the law the legislature passed, therefore.
Here, we're in a situation where the law didn't say anything about the corporate member's individual right to approve bylaws amendments. It didn't expand the governance authority of the board. It didn't eliminate the corporate member's voting rights. It just said that the makeup of the board changes. And corporate members used to have membership on the board, and we don't anymore. But that doesn't mean that we lost all other governance rights within ERCOT. And to get to your point about what we can do if the commission, as the corporate members, if the commission tells ERCOT to amend a bylaw. So if you look at TIEC Exhibit 3, I actually pulled out some of the provisions in 39-151 to give you an idea of what it means when PURA when PURA gives the commission the authority to just dictate something that ERCOT can do. So if you look at 39-151D here, this first section, PURA gives the commission complete authority to oversee and investigate the independent organization's finances, budget, and operations. And then if you go to the next section, it talks about financing. So it has complete control over financing, and it gives the commission may approve, disapprove, or modify a proposal for debt financing. And then for setting the agency's administrative fee, the commission can, it is set within a range determined by the commission. And there's a few more examples, I won't belabor the point, but if you go, all the way to the end here on on page 3, there's the language that we're dealing with here at the bottom, 39-151G1. It just says that the bylaws must be approved by and reflect the input of the commission. It doesn't say the commission may edit ERCOT's bylaws. It's not something that just happens the moment that the commission does it. Instead, the commission directs ERCOT to do it, and then ERCOT is under an obligation to reflect the commission's changes. But that process has to flow through ERCOT's approved internal government or governance processes.
And what if those two things that disagree with one another? I mean, just to use the example of this case, so the commission says, from now on, let's assume, I know this is exactly accurate, but from now on, the corporate members will have no ability to change the bylaws from now on. That's our input. What, I know you say then ERCOT has to go and follow their own corporate governing documents, but how do you reconcile that conflict? Because ERCOT, they have a choice.
So yes, and so to quibble just a bit with the question, I don't think that there's a conflict between the law there. There's no conflict between the PUC being able to order ERCOT to change things
between their input
versus what ERCOT actually does. So that's actually addressed on page 4 of TIEC Exhibit 3. So PURA lays out what the commission can do if the organization is non-compliant. If it can assess administrative penalties, it could apply for a court order to try to force them to do it, or it could decertify them. This is an issue that was discussed some in the dissent in the CPS Energy case that ERCOT raised in its briefing. Is ERCOT is not the subject of PURA 39-151. This just deals with one or more independent organizations certified by PURA. So if the commission is not satisfied with the way that ERCOT is dealing with what it tells it to do, it could decertify it. It could administratively penalize it. It has other options. But what it can't do is by fiat tell ERCOT that it can ignore its existing governance procedures in order to change its governance procedures. So if I could draw an analogy is, so imagine the legislature passes a statute that says, Commission, you shall adopt a rule that achieves objective X. So at that point, there's no doubt that the Commission's statutorily obligated to adopt a rule targeted at objective X. But the Commission can't point at that statute and say, the legislature ordered us to adopt a rule, so we're not going to follow notice and comment rulemaking procedures. And it's the same kind of thing here, right?
So if the legislature could pass a statute saying any of these independent organizations must have an entirely independent board, and then there would be no choice. You'd have to do, ERCOT would have to do that, PUC would have to approve it.
So that is what SB2 did, was it made the board independent in the sense of like an independent
I'm
director.
sorry, I should have said the bylaws. And could have included in SB2 that bylaws can be changed by the board without approval of the corporate members.
So I believe if, and there was a law proposed to that effect, and we cited it in our briefing, I don't remember the number, but yes, if the legislature had passed a law that says if you're an independent organization, you don't have to listen to your current bylaws amendment processes, the board can just do it, then yes, the board would have been able to do what they did here. But that's not what SB2 says.
So, but wasn't that kind of implied in I mean, this was radical change in ERCOT board. There was a radical, almost catastrophe. And wasn't that implied that we want an independent board of experts? Since experts are always right, that'll cure this ever happening again. And if they need to change the bylaws, have at it. Why isn't that implied?
Well, because it's simply not in the text. I mean, the corporate members' governance rights in the bylaws and generally in corporate law, the members' rights are different than the board's rights. And the issue that was addressed by the legislators talking about SB2 was, we don't want corporate members running the board anymore.
Right.
And we're not. And all we've preserved, or are trying to preserve, is our independent right that has nothing to do with whether you're on the board or not on the board. Every individual corporate member, and there are 280 some.
But if the corporate members vote, they can veto anything the new independent board wants to do as far as changing the bylaws.
So they could, in theory, if you can get a majority of the corporate member segments behind something. And
So- I'm sorry.
Yeah, in practice, so far as I've been able to tell, since 2000, the members have rejected one bylaws amendment.
Right. So, for me, not speaking for the court, but for me, I have excellent briefing from excellent lawyers on both sides on the textual analysis of who said what and what the statutes say and what the past history has been. And we're a textualist court, so that, of course, is where we start. But I'm also curious, what are you afraid is going to happen if you don't get the opportunity? What are the terrible consequences that's going to occur for your clients, for the corporate members, if the board, what are you afraid the board's going to do if they don't have to have your approval?
So the worry is that the corporate members could get cut out. And we understand we're not on the board anymore. We don't have that level of control over the organization. The concern is that we might get cut out of the stakeholder process, or that the stakeholder process might get marginalized. As in these expert board members might just be writing their own ERCOT protocols, adopting them, and we wouldn't have a part in them.
Well, you wouldn't be completely cut out, because the board, if the board amends the bylaws, it's got to be approved by the PUC. And the PUC does that by rulemaking, contested case, or informal conversations. I couldn't.
It's contested cases is my position.
So you would be heard then, right?
Yes, we'd be heard in front of the commission, but as it stands, the corporate members have the ability to prevent that from happening.
Right.
And we just don't want to live in a world where.
But you're not going to be cut out. You're not going to be, you'll have notice and an opportunity to be heard before bylaw amendments are approved.
Excuse me, could you?
Not in front of ERCOT, but not in front of the board perhaps, but in front of the PUC.
Well, if the commission applied its traditional contested case procedures, we would have an opportunity to discuss them with the board there. And Your Honor, I think we're talking past each other just a
Okay.
little bit. So what I'm talking about is the stakeholder process through which ERCOT adopts its protocols, the delegated rules that manage the electric grid. Right now, according to the bylaws and historically according to the bylaws, there are ways for the corporate members to elect the representatives that end up on those committees and end up voting on the rules that govern the electric market, that govern the grid. And the concern is not so much that we wouldn't be able to speak on the bylaws, it's that the bylaws would be changed in order to remove the corporate members' voice in the stakeholder
So
process.
you're worried about the protocols, not about the bylaws?
Yes.
Got it.
And I'm out of time on my initial, if you have any other questions.
Thank you.
Thank you.
Mr. Owen?
May it please the court. The questions from the bench, from Chief Justice Brister and Justice Field really highlight what is at the core of this case, which is the need for the Public Utility Commission to have control over the bylaws of its designated independent organization. And just to respond to the last discussion here, the TIEC will still have input into what those bylaws say, both at ERCOT, because the ERCOT bylaws as revised provided an opportunity to comment on proposed bylaws and even propose its own bylaws. And it would have an opportunity to comment at the commission as well, as you've noted. What they can't do, and what this change here was designed to address, was veto the changes to the bylaws that the new ERCOT board, the board that it consists of independent expert, deems are needed for the organization, because that is fundamentally inconsistent with the SP2 design, which shifted the power away from these affiliated stakeholders, like the large industrial customers, like the generators, like other types of players in the market, and shifted it to these independent experts.
He says, well, we're really concerned about the protocols. What input will they have on the protocols?
They will also have input in the protocols as well.
How will that occur?
That occurs through an elaborate stakeholder process at ERCOT. The protocols then in turn have to be approved by the commission. But most significantly, that there is a technical advisory committee that the stakeholders sit on. The legislature has addressed much of the concern that's been articulated today, because it has said ERCOT may not abolish that technical advisory committee without the specific input of, without the specific permission, rather, of the Public Utility Commission. So they're not going to be shut out. They will still have an opportunity for input. They will have opportunities for input, extensive opportunities at ERCOT on the protocols and on the bylaw amendments. They'll have opportunities at the commission. What they can have, again, though, is this power to frustrate what the new board may want. And that is the nut of what the commission was doing here. If you look at the statement of input that's included in the commission's oral argument exhibits, and if you look at Chairman Lake's memo discussing in greater detail why those amendments were necessary, they explained that it was important that the power to change the bylaws, be solely vested in the new board. And this is the problem. And this is what prompted the change that's at issue here.
Well, the legislature could have gone further though, couldn't it?
It could have spelled out in more detail, I suppose, if that's the question. It could have included a provision relating to the process for bylaw amendments specifically, but the statute didn't address that before, and there was no need for it to address it again. Post in SB2 and post Winter Storm Uri. I think it's of no significance that there is no specific provision in PURA relating to the process, because what matters is who controls the process ultimately. And the problem here is the veto, and it's clear from, or it seems apparent from TIEC's argument today that they want to hold on to that veto, that they're concerned about getting cut out of the process. They're not going to be cut out of the process, but they...
And does the record reflect what your side wants to do that they're not going to like? Or is that just speculation at this point?
I'm sorry, does the record reflect?
So you don't want them to have a veto. Veto assumes you're planning to doing, you may have in the back of your mind, not you personally, but you know, PUC or ERCOT or the board may have in the back of their minds something that they're afraid these folks, the corporate members, are going to veto. What are you all talking about? I'm not familiar enough with with Storm Uri and what the plans are to know what that is.
I don't think there's anything specific at issue here. I don't think, I can't point to anything specific in the record. It is clear in the record again, and I point to the statement of input as well as to Chairman Lake's memo relating to the statement of input, discussing why it's important that the board have the sole power over the bylaws. So was there some specific thing that the board might want to do, that there was a fear that TIEC's members might try to veto? Not to my knowledge, and I don't believe the record indicates that. But just as a matter of governance and to make the bylaws reflect the way ERCOT is governed, post SB2, the change was necessary.
So, I'm sorry, go ahead.
So is SB2 a crucial component of your argument here? Is this something that the board could have done all along, or is it just SB2 that then creates a statutory basis?
Well, SB2 is a piece of it, but it's also important what the Supreme Court has said in the CPS Energy case, and what PURA has long said before SB2, which is that the commission has complete control over its independent organization, and that includes its bylaws.
And so you're saying the statement of input, when the statute says input of the commission, is that what we're talking about? The statement of input is that input?
The statement of input is that input. The statement of input was the commission's directive to ERCOT to change its bylaws to make them comport with what the commission wanted. Again, the commission has that complete control.
Just to distill the argument a little bit, you're not denying that under the bylaws as they were, that the corporate entities had the ability to veto. You're saying, even if they did, our input was, that needs to be taken away and the bylaws amended.
We think there's an issue as to whether that power was found under the old bylaws, and we discussed that in the briefing. We have a disagreement with TIEC about that, but it doesn't matter whether it provides that power or not. Ultimately, the TBOC issues don't matter because the commission has this complete control. CPS Energy, as you had noted, the Supreme Court has made clear that ERCOT functions as an arm of the state, and everything it does under the direction of the PUC.
So I'm just wondering, are we creating more litigation? I mean, you know, you all have quite an industry of PUC appeals and cases to the Supreme Court and all that stuff, but it's a highly regulated business. It's an arm of the state. I've got all that. But these are huge investor utility companies. And if you shut them out too much and you spoil their investor-backed investment expectations, you end up with takings cases. And so I'm wondering if, my reason for the plan is, if I understand addressing the catastrophe, but I'm just wondering where we are headed is we're going to cut these people out of the process and they're going to sue us all and we're going to have huge litigation for years about whether it was a government taking or not, because you have no immunity if you take their investment-backed expectations by regulation.
I don't believe what we're talking about here is shutting them out of the process. As I was saying, they have that input into the bylaws, into the protocols, through the technical advisory committee, and nobody's talking about, to my knowledge, about.
Well, not now.
Not.
But if you do, then that's what's going to happen, right?
Well, the legislature has addressed that. The legislature said ERCOT can't do it unilaterally. They specifically said if ERCOT wanted to try to do that, if it wanted to try what might be the fear, then the commission has to approve that. And then, of course, the commission, being a political body in this state, is subject to all the input that it gets from state officials and from the public about what it's doing. So part of the commission's job is it does a lot of balancing.
Sure.
It has to balance the needs of electric consumers. It has to balance the need for everyone to, for a reliable electric grid. It has to try to avoid the sort of incident we saw in 2021 where there was an extensive outing. It also has to factor in the needs of the market participants, the particular situations of the large industrial customers and the generators. The state wants to promote generation development in this state. The state wants to promote and encourage the large industrial customers like TIC represents. So there's no effort to cut them out of the process, but what drove this particular change was a need to make clear that sole control must rest with the commission itself. And that was necessary, again, because the statute says that the commission has complete control. The Supreme Court has made very clear that ERCOT is a very unique kind of organization. Counsel for DIC was talking about the fact that it's a nonprofit organization. Well, yes, but it's a very special type of nonprofit organization. And it's a nonprofit organization that has been designated by the commission to serve as the grid operator. And it only serves that purpose in accordance with the commission's directives. If it were to defy the commission's directives, ERCOT, it could be subject to sanctions. It could even be subject to the ultimate penalty of decertification. So I do think it is important to keep in mind here that what we're really talking about in this case is the commission's directive. That's what's at issue.
Right.
It's consistent with PURA.
We've got that.
Yeah. So a lot of the TBOC argument that we haven't heard a lot about it today, but it's extensively discussed in the brief. It's really not the core of the case. And they haven't argued that this directive is inconsistent with PURA. They're simply arguing that they don't like it and they would like to hold on to that power that they had before. But if the commission directs ERCOT to make this change as its designated grid operator, ERCOT has to make the change.
What was their remedy procedurally in the administrative process to say, wait, PUC, this was a bad idea, let us tell you why, let us present some evidence? What was their remedy?
During this particular approval process?
Right, because it was seemingly quick, because what their complaint was, it was,
The next day.
right.
Well, that's misleading, I believe, and because, or it is misleading certainly, because in fact, the discussions of making this change to the ERCOT protocols started months before then. It started at ERCOT, where there was discussion of whether this change needed to be made. And after some discussion and opportunities for comment and market notices where ERCOT puts everybody on notice that something is potentially in the works, ERCOT filed a request for the statement of input, and that statement was issued.
So it was, it happened quickly, but they knew it was coming.
It happened relatively quickly. It's very misleading to say it was rubber stamped.
Got it. I think Mr. Clark looks very antsy. Are you using up some of his time, or?
I am not.
Okay, good.
I will complete.
Take your time then.
Well, I see that I have 16 seconds left, but I will yield my 11 seconds to Mr. Clark.
Thank you, Mr. Hope. Mr. Clark.
May it please the court.
So you're going to tell me you don't want to cut them out, right?
No, sir, we do not. And that's been made clear, and it is in the record, and we have in our oral argument exhibit 3, a timeline of events. And in that timeline of events, what you see is when ERCOT first put this notice out, it received comments back from its members, and the main complaint, the primary complaint was, hang on a second, you could now eliminate TAC. That's the Technical Advisory Committee. And ERCOT made clear that's absolutely not our intent. And so they amended the amended bylaws to make clear ERCOT will not eliminate TAC. If that was even a consideration, it would first have to go to the PUC. And the fundamental flaw in the other side's argument is if the PUC decided TAC has outlived its usefulness for whatever reason, and I highly doubt that will ever happen, it surely has that prerogative. And so this goes back to ERCOT is unique, as everyone has said, and it doesn't fit neatly into any traditional governmental entity form, but the Supreme Court has told us definitively it is an arm of state government. It's not a run-of-the-mill garden variety nonprofit corporation whose governance can be determined solely from TBOC. Its governance is first and foremost determined by PURA. And according to the appellants, the corporate members that are now legislatively prohibited from continuing to serve on the board have the power to gridlock the PUC and the new independent state-appointed ERCOT board from getting anything done. They said it today. Well, what will happen in their mind is the corporate members will veto the PUC and the state's board, and then the PUC will have to go and sue ERCOT in a court to make it comply because these corporate members that no longer have a seat on the board think they have that veto power. So if you think about that, what they're asking this court to do is to strip the PUC of its complete control over ERCOT's bylaws and bestow it upon them to give them the power to veto the state. That would be an absurd and unreasonable result. It's not supported by the text of PURA, and it's completely contrary to the Texas Supreme Court's CPS Energy opinion. And
In fairness to them, I mean, that is what the statute sets out as a remedy. So, I mean, if I'm in their shoes, I'm arguing, I hear what you're saying, but the legislature could change that if they wanted to.
They could, but the legislature had on the books long before that, the PUC must approve ERCOT's bylaws, and those bylaws must reflect the input of the PUC. That was already the law. That's been the law since 2005, I believe. And so when the PUC gave its statement of input, ERCOT had no choice. And to think that the corporate members could say, well, PURA says our bylaws must reflect the input of the PUC. The PUC has said, here's our statement of input, change your bylaws to this, that the corporate members could then say, I don't think so. We don't like that idea. We're not going to do that. We're going to veto you guys. That's the result that they're asking this court to come to, and it's simply not reasonable. And it shouldn't be controversial to say that the PUC has complete control over ERCOT's bylaws. The Texas Supreme Court said that in CPS, and as you see in our oral argument, Exhibit 5, the TIC has told the Texas Supreme Court exactly that in its amicus brief in Panda Power, which was decided with the CPS Energy case. And so when you get to the statement of input, which has been ignored, as we pointed out in our brief, and then go to the order that they're complaining about. The order that they're complaining about talks about that statement of input in findings of fact 3, 4, 5, and conclusion of law 3. They have never challenged anything except one phrase in finding of fact 3 and ignored the rest. So when you go to the order, is that order supported by this substantial evidence when it says, we issued this statement of input and then finds these amendments comply with that statement of input, and Pura says the bylaws must reflect our input. That's it. It should be over at that point, and they got the main concern, the fear. I would say that, to Chief Justice Brister, your point, this idea that there's a future wave of takings is, I don't think it's going to come to pass, but more alarmingly in the present, what if what happens is the corporate members can now gridlock the PUC and ERCOT? We want to govern the state entity, this arm of the state, in this way, and the corporate members pop up every so often and say, nope, not going to allow it, go decertify ERCOT. And so then what happens? What's the remedy? ERCOT gets decertified, reconstituted as a separate incorporation in some other form without any of these corporate members? I mean, it's an absurd result. And to the point of the TBOC, it's not illegal to make a choice under TBOC. We outline why we think they're wrong, but it is not illegal to choose between these elections. They are there. The default rule is the board has the power to amend the bylaws. I'm over my time, I apologize.
No, please finish your thought.
The default rule is that the board has the power, and you can make 3 separate elections. Those are choices. Companies can make them. Obviously, ERCOT's not a garden variety company. But it is not illegal to say, we don't want these exceptions to apply. We want to go with the default rule. It's an election. And if the PUC wants to make that election, it's not a violation of TBOC. It is a choice that they made.
Thank you.
Thank you.
You may proceed.
So I wanted to start by circling back to one of your questions, Justice Field, about what remedy TIEC had at the commission. And I feel like it's important to emphasize that the vast majority of the activity they were talking about occurred at ERCOT board meetings, ERCOT committee meetings. And normally, after discussions like this happen at ERCOT, and after ERCOT makes a decision, then there's a contested case hearing at the commission. So the total things that happened here was the commission discussed amending the ERCOT Governance Committee discussed amending the bylaws, I believe in August of 22. Then November 9, I believe it's November 9 and November 11 of that year. November 9, ERCOT filed proposed amendments. And then on the 11th, 2 days later, the commission issued a statement of input. So they didn't solicit responses, they didn't solicit comments like it was a rulemaking, they didn't tell people they could intervene. This was all done in a project titled Year-End 2022 Reports of ERCOT or something along those lines. It wasn't in a separate docket where they were telling us what was going to happen. So they issued this statement of input, something the commission's never done before a bylaw was adopted on a prospective bylaw. We can't challenge that. That's not a commission order. They didn't approve anything. They didn't make anything happen. That's not a final order of the commission. And it's not right for challenge. Then, when it did come back to the commission, it was, I believe, December 19th. There was the ERCOT made a filing saying, we're going to approve these bylaws. The 20th, the board approved them, the commission approved them, they issued an order. And once again, that was in that separate project, mixed in with a bunch of other stuff. And every other time they'd done that, approved bylaws and given input, it was in a contested case. And I'm not going to belabor the procedural language in the commission's rules, but every other time they'd done it, it was in a contested case. And even up till December 19, when ERCOT filed a petition that said, we have approved these bylaws, we were fully under the expectation that the commission was going to file and manage it as a contested case, where we would get an opportunity to intervene and participate, not at ERCOT, but at the commission. And it's clear from the Encore v. Public Utility Commission case that we cite in our briefing, the commission can change its interpretation of its rules, but it can't do it on a dime without telling anybody that it's going to change the procedures. And it can't do it without explaining the reasoning behind changing its interpretation of its rules. And here, we just showed up one day and there was an order. And so the answer to whether we actually had a remedy at the commission is not really. I mean, we filed a motion for rehearing, but that's about it. So I'd also like to address the gridlock argument. I think that was a kind of a drastic overstatement of the implications of this case. ERCOT's bylaws, they've been amended, I think, 8 times since the year 2000. This is not something that happens every day. It's not something that affects the day-to-day processes in ERCOT. So if the ERCOT board wants to pass a new rule, it does that. The members can't stop that. The members don't even have the opportunity to unilaterally pass our own bylaws. All we can do under the pre-2022 bylaws, all we can do is if a majority of the market segments say we don't want a bylaws change, we can stop it from happening. And the reason that we want that is to prevent ourselves from getting into a lot less advantageous of a situation here. So World 1, where we lived in 2022, is in order to eliminate TAC or marginalize the stakeholders or make it irrelevant to the process, you had to have the corporate members on board. Now you don't. And that means that the ERCOT board and the commission can go to the corporate members and say, do X, Y, Z, or else. And I'm not saying they're doing that. They're not. Everybody in this room wants the grid to run well. You know, the members we haven't been blocking bylaws amendments. We've done it once ever in 2005, and it was a line item type thing. I mean, we're not trying to hold anything back. We're just trying to make sure that ERCOT is governed in accordance with its governing documents. And the PUC can't just give input and tell the ERCOT that it can ignore its governing documents, what they say right now, and it can ignore the TBOC and just act as though those documents have been changed in order to change them. If you have any questions, please let me know.
Thank you.
Thank you.
Thank you, counsel. The case will be submitted. Marshal adjourn the court.
All rise. Court of Appeals for the 15th District of Texas now stands adjourned.